Afternoon to everybody. I uh, Before we get started, let me just introduce myself. My name is Jim Roberts. I'm the estate planning attorney. Basically started the law firm about 36 years ago. And so for a lot of you, I look around and I see very familiar faces. I want to welcome you here today to Family Day. This morning we started, I'm going to ask the same request. Before we get started, let's just take about 15 seconds, 30 seconds of just silence for what's taken place in the country in the last week. I know that last year when I did this, let me ask a question. How many of you were not here last year? Okay, quite a few of you. Perfect. Because there's been some law changes, but there haven't been dramatic law changes in the last year. So for those of you that were not here last year, this is great. We have enough to cover to keep you interested, I hope. Last year when I was doing this, I put up a subtitle, and it was Creating Certainty in an Uncertain World. And if everybody will remember, in October of last year, it was right before the election. And I think that there was a lot of uncertainty. Today, it seems like there's not much harmony. And what I see is going on so often is that in families, there's not harmony. And part of what that happens is that if we do things correctly, I'm not going to sit here and say just because you do every step correct as the successor trustee, everybody's going to hold hands and sing Kumai Law together. But it's so much better than when the train jumps off the track and now people are accusing you of doing things wrong. And so part of today is to help educate and to share with you basic information so that you keep the train on the track. That's the whole goal. And I truly do believe that harmony should be the new normal. And if we're going to have harmony as a country, if we're going to have harmony throughout the world, I really do think it starts with our families. But how many of us have challenges in our families where there's not harmony? I know this is being recorded, so my siblings can see this, but I was my parents' successor trustee. My parents had a wonderful attorney set up their living trust for them, and you didn't get that. My parents had a wonderful attorney set up their living trust for them. But in my family right now, and I think it's kind of moving past it a little bit, but my brother won't come to my house for Thanksgiving if my sister's going to be there. And that's not what we want for our family. And that's that harmony. And it really should be, if we can't have harmony with siblings, how are we going to have harmony with North Korea? And think about it. And that's really what's happened. And so part of the estate plan is to eliminate the government process and to reduce some of the family headaches, family fighting, the family challenges. So I'm going to give you as soon as I turn this on, I'm going to give you that, maybe. Our objectives, first of all, our objective is help building a bridge from the trustor and the successor trustee. A lot of my clients, I look around the room, I see clients that have been my clients for many, many years, and they understand their living trust. They understand that they have a trust that says while they're alive, they can do what they want, and they've named successor trustees to step in to pay bills, write checks. The challenge comes that just because David and Charm understands their trust doesn't help Lisa, who is going to be tasked with implementing the trust when mom and dad have passed away. And so today it's building that bridge. And what I mean by that is that when my mom and dad passed away, if I knew what to do as the successor trustee, there's a bridge from one generation to the next. I think it's critical. So that's really the focus, is just to give you some basic information today about how to implement the trust, how to get started. In addition to that, we're going to help educate the successor trustee to ensure that the trust is properly implemented. Can there be mistakes? Yes. Most mistakes for most people are just they don't know. What we don't know, we don't know. And so, for example, most people don't know that within 30 days that whoever has possession of the will, they are supposed to place that will in a safe that's maintained by the county in which the person is passed away. Well, if you don't know it, you don't know it and you're not going to comply with it, but that doesn't excuse you. Probate Code Section 8200 says anybody that doesn't comply with that is responsible for all damages. And it's just one of those things, and so we're going to help make sure that you know what you should know. On top of that, discuss better methods to protect your loved ones. Part of this afternoon's presentation, Holly's going to be the one doing it, but we're going to be talking about additional problems, additional solutions. I have found that for myself, when I'm meeting with clients, about over 50% of my clients today choose not to leave their assets going to their son and their daughter, but actually for their son and daughter. And as Holly's going to point out, if you leave it to them, if they were to go through a divorce, their spouse has a potential interest in the inheritance, and it's subject to their creditor claims. By leaving the money for my daughter, if she goes through a divorce, her husband has no presumption of an interest in her inheritance, and if she got sued, her creditors can't take that money. So additional problems, additional solutions. Holly's going to spend some time talking about that. And then finally, I get up here. I've been an attorney now for 36 years. I've literally helped over 10,000 families avoid probate, reduce taxes, just get their affairs in order. I am more excited about the options, the flexibility, the capacity of a revocable living trust today than I was 36 years ago when I first started doing these things. And so anybody that doesn't have a trust, listen. The focus is really to explain how to implement it, but the second focus is to say, you know what, maybe I need to get a trust set up. By the way, I know a very good law firm that could handle that. It's the same one that set up my parents' trust. And so, in case you haven't figured that one out yet. So that's kind of the objectives. On top of that, I have an outline. First of all, the welcome. That's what we've accomplished. How a living trust avoids probate. I'm going to share some information because when Holly starts talking about how to implement the trust when mom and dad have passed away, if you don't understand the basics of the trust, you're kind of like starting on quicksand, not a solid foundation. So I'm going to spend a few minutes explaining how a trust works and how the trust avoids probate and why you'd want to avoid probate. Also, we're going to talk about additional problems, additional solutions. I'm going to come back up and talk about administering a trust upon incapacity. So if a loved one starts developing dementia, has a stroke, not able to take care of their own affairs, what your parents have done is they've set up their affairs so that you will not have to go into court and have the court appoint somebody to administer their affairs during incapacity. A lot of what we're going to be talking about today deals with this right here, trust administration, avoiding missteps when administering a trust. And that is when mom and dad have passed away, what are the steps? And we're going to give you an outline for that. I'm going to come back and talk about next steps, raffle. We do have a raffle coming up. And so be aware of that. That'll give you an incentive to stay. That's the whole idea. And so with that, I do want to point out that we have a website. It's in the material, so you don't have to write it down, but webuildyourtrust.com. And that has a lot of information, a lot of videos, a lot of just useful information. So one of the preferences for today is that please silence your cell phones. In the earlier one this morning, the phones went off twice or whatever. And what I tell people is, I don't mind if the phones go off, but just be aware that if they do go off, I have to start all over again. And my name is Jim Roberts. I'm an estate planning attorney. So if you don't want to hear that, you might want to silence your cell phone. And one of the things we're going to ask is that you hold your questions to the end. Holly and I will come back up and answer questions. I'll just share with you, I happen to have been supposed to be in a meeting in LA today. So after this, I'm driving directly up to a meeting. Going to join it obviously late. It started at 8:30 this morning, but I will be there. So I'm not going to stick around too long, but Holly will be here and my staff will be here as well. Okay? With that said, the Living Trust, and keep in mind the purpose of this is to explain why have a living trust. The primary purpose of a living trust is to avoid probate. Let's say that I have a home. I'm a single man, so the title to my home reads James F. Roberts, a single man. If I wanted to transfer the title to my 2 children, I would pull out a deed with a pen, sign the deed that says James F. Roberts transfers it to Dustin and Diana. I'd have my signatures notarized, and I would have it recorded at the county recorder's office, and that would transfer the title from Dad to the 2 children. Okay, so everybody understands, as long as I can sign my name, life is good. The challenge comes at my passing. What is the one thing I can't do? Sign my name. And so what happens is if a parent passes away or both parents have passed away and their name is on title to their home, for example, how does their name come off and your name is put on? Well, instead of having them sign the deed, traditionally what has taken place is that the probate judge signs his or her name, and that takes it from James F. Roberts, who's deceased, over to Dustin and Diana. But it's the judge's signature, and that is what probate is. And so probate is the purpose of a living trust is to avoid the probate process. And probate is the government plan for those who don't plan. Now, what is probate? The government steps in and supervises the changing of the title from Dad over here to my 2 children. Probate also involves assuring taxes are paid, assuring creditors are paid, assuring assets are properly valued, and assuring that those involved in the probate process are paid. I'm happy to report that one of the judge's biggest concerns in the probate process, biggest concern, is that the attorney gets paid. There was somebody in the earlier session today that I handled her mother's probate, and I made a significant amount of money handling her mother's probate, and I just took statutory fees. But when I share, it was so much more than I bill on an hourly basis. It was at the $6,000 per hour range. And all I got was statutory fees for handling the probate process. So and we'll talk a little bit about that. And so the reasons to avoid probate, first is the time element. If I passed away today, being October 7th, 2017, the average time period before Dustin and Diana would receive the access to the estate is between 1 to 2 years. So that means October of 2018 to October 2019, it's tied up in probate. Can it take longer than that? Yeah. I personally was involved in a probate down in Long Beach. It took 13 years. John Wayne's estate. John Wayne passed away with a will. His estate took 18 years here in Orange County to go through the probate process. Now, probably, maybe mom and dad will take you out to dinner or something, but if they do take you out, the next time I would sit there and tell them, thank you for eliminating 1 to 2 years of your life being tied up in court, passing by going through probate. Because that's what they did. They set up a living trust to avoid the probate process for you. So time is one of the factors. Another factor is the cost. It turns out, for example, if a person passes away and they have a $800,000 estate, the minimum attorney's fees on an $800,000 estate in California is $19,000. So for the transferring of the title, if you have an $800,000 home, for the transferring of the title, the attorney gets paid $19,000. For setting up of a living trust, we only charge $18,999 now, so it's much cheaper. But the point being is, most people don't want their family to lose that type of money. And it's not just the attorney's fees. There's court costs, there's an executor's fee, there's bonding costs. By the time you pay all the expenses, you're looking at about 5 to 10% of the fair market value of the assets are generally lost going through probate. Again, when your parents take you out to dinner, at least that's how it works in my family, when your parents take you out to dinner, thank them. Because again, when they pass away, because of what they've done, the things that they own will go to their loved ones, to you guys, without that 1 to 2 year delay, without that 5 to 10% loss in the fair market value. The final reason to want to avoid probate, in my opinion, I use the term headaches. I see it that when somebody passes away, and in a relatively short time, Holly's going to be talking about it, but in a relatively short time, I'm able to go to my siblings and say, here's your fourth, here's your fourth, here's your fourth, and here's my fourth. That is so different from a mindset than saying to my siblings, we're going to spend the next 18 to 22 months going through a government process that the government's in control. I can't make any distributions. And it lends itself to somebody saying, oh, I don't think I'm getting my fair share, and blah, 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 and a sister-in-law or a daughter-in-law or somebody getting their nose into the business, and it just lends itself to a lot more disharmony. If I can advise anybody why I think you should avoid probate, it's eliminating the headaches here. And I use headaches as a way of describing the family fighting. And I wish that I could tell you that in my own family everything went perfect. Everybody's saying Kumai together. I was the trustee. I get along with all of my siblings. My observations are my siblings don't get along with each other. And they weren't super close, but having money, having issues that come up did not bring us closer together. So you want to stack the deck as best you can in your favor. All really a trust is a contract. So I have this situation here in which, rather than thinking about this complicated legal document, if you can understand how a bucket works, you can understand how a living trust works. There's 3 parties to a bucket. There's 3 parties to a trust. There's somebody who puts something into the bucket. There's somebody who manages what was put into the bucket. And then there's somebody that gets the benefits of what was put into the bucket. The person who puts something into the bucket is called the trustor. So if you're married, the two of you were the trustors. If you're single, you're the sole trustor. The person who manages what was put into the bucket is called the trustee. If you're married, the two of you are the trustees. If you're single, you're the sole trustee. When you cut through all the fluff that goes into a revocable living trust, all this trust really consists of is a contract between the trustor and the trustee that says, while I'm alive, I can do whatever I want to do. Now, my trust is Jim and Gail Roberts, so the trust is a contract between my wife and I as trustors, and my wife and I as the trustees, that says we can do anything and everything that we want to do, period. And the third party is the one that gets the benefits of what was put into the bucket. And it turns out that while we're alive, Jim and Gail are the sole beneficiaries of our trust. So we're the trustors, trustees, beneficiaries. When I pass away and my wife becomes the trustee, my hand comes off, she becomes the trustee, she's the trustor, she's the beneficiary, she can amend, she can revoke. It's her trust to do what she wants. That works fine up until the time that she passes away. Now, at the death of the survivor, that's when we are generally going through that probate process. But instead of going through probate, as Holly's going to go into a lot more details, my children, if they were named as the successor trustee, would basically take 3 documents: a death certificate for Gail, the trust document, and a tax ID number. And Holly's going to go through that. But Gail's Social Security number ended the day Gail passed away, so she has to get a tax ID number. With those 3 documents, they go to Wells Fargo, go to Merrill Lynch, wherever our accounts are, and the accounts get re-registered. So instead of them reading Gail, trustee of the Roberts Family Trust, they now read Dustin Diana, trustee of the Roberts Family Trust. At that point, their name is on the handle of the bucket, and they're now in control of the assets, which is about the equivalent of where the court would be at 18 months going through probate. It doesn't always happen this fast, but this element right here, where they're in control, is about a week, 10 days. Oh, by the way, my name is Jim Roberts. I'm an estate planning attorney. We're lucky we're not past halfway, I'll tell you. If you get past halfway, it starts a riot around here. But the point being is that you have a situation that my children didn't go through probate. They get their hands onto the handle of the bucket and are now in control. So just a few slides. Your handout, I chose to make your handout more complete than what I've covered up here because I like to talk. I don't like to go through slides as much. But what are the terms? While Gail and I are alive, we can amend, revoke, add property. We can collect all the income, get all the principal. Nothing changes. In other words, we can do whatever we want. Transferring our assets to our revocable trust. One of the things you want to transfer your assets, simply change the title. So our home, in my situation, does not read Jim and Gail Roberts as joint tenants. It now reads Jim and Gail Roberts, trustees of the Roberts Family Trust. And we give you an example here on real estate, your bank accounts, your investments. You would have them read Bob and Mary Smith, trustee of the Smith Family Trust. Somebody asked me a question today, and I said I wanted, if I didn't bring it up, to raise his hand. There is not a huge scam going around. I mean, it's not millions and millions of dollars. But when you record any document by absolute state law, it's public information. I can pull up the deed on anybody's home. I have a service that we pay for, and so that I have access to people's deeds so I can look at it. One of the things that people do is when you record a deed, they'll send you a letter saying, oh, you need to get a certified copy of your deed and send us $75 or $100 and we will create a certified copy for you. It's fraud. I mean, it's not fraud. It is a scam. You don't want to send in your $75 or $100 or whatever it is, because first of all, when you get ready to sell your home, nobody's going to ask for any of your documentation. The only documentation they care about is the one at the county recorder's office. And so you don't need a certified copy. So just be aware, if you record a deed and you get a letter in the mail saying you need a certified copy, send us $100. Send the $100 to me instead for that advice. Okay, so what doesn't work? And I've talked about how a trust works. What does work is a revocable trust. What doesn't work, putting your kid's name on title, because if, for example, Dave and Charm was to put Lisa's name on title, and Lisa was involved in a car accident, her creditors can come after Lisa's assets. What are Lisa's assets? Mom and Dad's home, Mom and Dad's bank accounts. Also, if Lisa was to go through a divorce, there's a presumption in the state of California that says everything a married person owns is presumed to be community property. Well, if her name is on title, her husband now says, I want my part of my in-laws' property. Guess what? It lends itself to great bargaining chips in the divorce action. Can you see how that, even if the son-in-law doesn't really think he's going to get something, that doesn't matter. If he thinks he has a way of causing mom and dad to be under stress and so forth, Lisa's going to give up more on her retirement or something else in exchange to protect her parents' home. You don't want to put your kid's name on title. And Holly's going to spend some time talking about how to protect those assets. And compare the trust to a bucket. There are 3 parties to the bucket, 3 parties to the living trust. And the trustor created the trust. The trustee manages what was put in the trust, and the beneficiaries receive it. You're all 3. And that brings us to, I hope you get just a basic introduction. The idea is that we're trying to avoid probate. How we avoid probate is that we have a trust that says, while mom and dad are alive, they're the trustees. At their passing, we've named a successor trustee. And now what we're going to talk about is some planning strategies. And Holly, let me just share something. The clicker changed.
Left and right. Yes.
Perfect.
Thanks.
This is Holly Nabier. Let me introduce Holly very quickly in case some of you may not know. Holly and I have been working together for about 6 years. And in the law field, being a board certified specialist is a very rare occasion. Turns out that less than 0.5% of all attorneys are board certified specialists. You have to be recognized by your colleagues in order to be a board certified specialist. You have to have certain periods of time with certain amounts of cases in certain complex areas, and you have to take an additional bar exam. Holly took the bar exam before she even had the experience, and she passed first time. And she is a board certified specialist, recognized by her colleagues, recognized by the bar for being extraordinary. On top of that, Holly is recognized there's a category called super attorneys, the top 500, and she is among the top 500 attorneys in the United States. So with that,
thank you. I wasn't expecting that kind of an introduction, but thank you. Now I really have to deliver.
I teach her well. That's the whole idea.
Okay.
I take all the credit. No, I wish I could, but Holly is really a special. You'll see that as she goes through this.
Jim.
You're welcome. Thanks. I'll be back.
Thank you. So what Jim has been sharing with you up until this moment has been how the trust works, the mechanics of a trust. And for those of you who already have a trust, you're probably familiar with that. But for those children and successor trustees who are here, hopefully you have a better insight as to the logistics of a trust. And one of the main reasons why people establish trusts, as Jim shared, is probate avoidance. We've set up at this point thousands upon thousands of trusts, mainly so that those assets pass to your loved ones without the court probate process. But there are additional reasons why people set up a trust. It's not just to avoid probate. And so I'm going to go through what some of those other reasons might be. We've just kind of given you some bullet points that I'm going to expand on, but there are traditional problems such as young beneficiaries or spendthrift beneficiaries who can't manage money well, or beneficiaries who might have some lifestyle problems that we need to address through the trust document. There are special needs beneficiaries. There are beneficiaries who we need to protect from their spouses and from their creditors. There are maybe retirement accounts that you have that we need to leave to the children a special way. Maybe there are pets that we want to provide for. And then perhaps we have a large estate, large enough where we have an estate tax problem. Having a trust in place helps us deal with all of these additional types of problems. Aside from just avoiding probate, we can address all of these through the creation of a trust too, and we do so on a daily basis. So I'm going to go through these problems and identify them one by one and just give you a glimpse of the type of solutions we have for each of them. Traditional problems would be, let's say, an immature beneficiary. You might notice that in your trust, it might say that everything is going to your children outright. But if you have any provisions for a minor, or let's say a child who's not yet reached the age of 18 or 25, or maybe there are provisions in there as to what happens if one of the children should, in a heaven forbid scenario, pass away before you, and now their share is going to trickle down to the grandkids. The trust has to address what's going to happen to those younger beneficiaries' shares, because when is the last time you gave money to an 18-year-old or a 16-year-old or a 21-year-old to the tune of hundreds of thousands of dollars and they spent it wisely? Probably hasn't happened, and it doesn't happen very often. So the trust has provisions in place that will say, as to those immature beneficiaries or those minor beneficiaries, we can hold their inheritance, continue to have their inheritance held in the family trust, have it available for them in the discretion of the trustee that you've named, have it available for their education, so tuition, books, supplies, have it available for their health, braces, or whatever work they need done, for transportation, for reasonable things. But when they've reached a certain age, then they'll get the bulk of their inheritance. So we can do that through creating special provisions in the trust. But then we have clients who have children who are well into adulthood. They're not minors. They're in their 30s or 40s or 50s, 60s and 70s even. And these are children who just don't know how to manage money, let alone hundreds of thousands of dollars. And the clients aren't comfortable just handing it all over to them. So we are able to, again, have the trust have certain provisions in it. So in this document here, the very lengthy trust document that you might be familiar with, inside there it will say, as to this child's share, it's to be held in trust for him or her, and it's to be distributed for their reasonable needs in the discretion of the trustee so that they can't just take it all and blow it all in one shot. So that's how we deal with spendthrift beneficiaries. And then life management problems. Not necessarily people who can't spend money or are too young, but people with drug or alcohol abuse problems. And you might think that, I have clients come in, not uncommon to come in and say, I love my children equally, but one of them is living on the streets, or this one abuses drugs or alcohol. I don't want to disinherit them, but I also don't want to enable them by leaving them hundreds of thousands of dollars that they're just going to blow and spiral downwards into a further addiction and perhaps even death because of a result of their inheritance. And so what we can do is we can write in drug testing provisions, and we might say that this person's share is held in trust for them until they pass a blood or drug or urine test or a test that tests negative for drugs. And if they test negative, then maybe they'll get a distribution. If they test positive, they lose that distribution. And we might say that it goes to a charity, or we might say that that money goes to their siblings, but we can customize it in any provision that works best for you and your beneficiaries. I know that doesn't apply to a lot of people, but I just want you to get a sense of how a trust can be drafted to really accommodate all of those different circumstances of your life. Special needs trust. So when I say special needs, I don't mean somebody who has some rare special form of illness or, debilitating disease. A special needs trust is really catering to those individuals whose children receive some form of SSI or Medi-Cal. SSI and Medi-Cal it's a government program that the state of California has in place to pay for the prescriptions, co-pays, doctor's visits of people who qualify for that aid. And you qualify if you have some sort of a disability, Maybe it's a mental disability. Maybe it's depression or bipolar condition. Maybe it's a physical disability, multiple sclerosis or MS, or some other condition that renders you unable to work or earn an income. Coupled with not having enough resources of your own, generally there's like a $2,000 resource limit as to how much you can have in the bank. And if the government sees that you do have some sort of condition and you do have limited resources, they will pay for your medical visits, your premiums, your prescriptions. They will even give you money at the end of the month to pay for your food, clothing, and shelter. But they do so on the condition that you not have a ton of money of your own, which makes sense because if you came into an inheritance and you now have a large sum of money available to you, why should the government pay for those costs? Well, a lot of our clients have children on SSI or Medi-Cal receiving those benefits, and they don't want to jeopardize those benefits because they are, in fact, very valuable. We had a client just last month who the trust didn't have a special provision in place for him. It did not mention anything about a special needs trust. It just said he gets his inheritance outright. He was on Medi-Cal. He still is. He has some sort of a condition that requires a catheter placed in his back and a drug doses being administered to him automatically through this catheter. And the expenses are to the tune of $20,000 a month. That's what his medical expenses are. And the government pays for that through Medi-Cal because it is something he clearly can't afford. There was no special needs trust in place when he received this distribution. So he was about to receive this distribution from the trustor's trust. We had to go into court and ask the court to modify the trust to include one of these in there so that he can still get his inheritance to supplement the government aid. So you can see how a special needs trust can be so valuable for those individuals who are on SSI or Medi-Cal. And really the essence of a special needs trust is holding the funds in a bucket for the beneficiary and really supplementing the money that they're receiving from the government, but not replacing it. And the government allows us to do that. So if you or a loved one or you know somebody or a beneficiary of yours receives this form of a benefit, it's so important to have a special needs trust in place within your document. Creditors and divorce. So, not all of our clients' children have the healthiest marriages, and not all of them are in the safest line of work, and there might be a lot of susceptibility to malpractice or lawsuits or judgments, and they're scared, quite honestly, to just leave their children an inheritance without any further provisions. So one of the things that we can do is, rather than leaving the assets outright to the children, we can create protective trust funds for them. And why would we want to do that? Because if we distribute the assets outright to the child, if soon after your death the trust dissolves and the assets are just distributed to your son and to your daughter, what happens if they have a failed marriage? What happens if they go through bankruptcy or if they have creditors? Those assets that they have now inherited that belong to them personally and individually are subject to the claims of their creditors and divorcing spouses. There is no protection for those assets once they leave the trust and you hand it over to them. So one of the things that we can do is we can shield those assets through the creation of what we call a lifetime protection trust. And the lifetime protection trust it's not a means of restricting the children. What we're really doing is just protecting them. And we're saying, when I, as your parent, die, I am leaving you this bucket of money. But I want the money to stay in the bucket, and I want you to manage it and invest within that bucket. So if you need to buy a home, but in the name of the trust. If you want to buy some stock, some Apple shares, do so, but in the name of the trust. Everything you're doing is under the umbrella of the trust. And the child himself or herself would be the trustee of that trust fund. So they really don't have any restrictions as to how much they take or how they spend it. But the beauty of it is, because it is in a trust for the child, and it doesn't belong to them, individually, but it's held in a trust for their benefit, that distinction makes all the difference in the world, because now their creditors can't come after it, their spouses who divorce them can't come after it, and so it's a really important type of trust to have. So how does that trust work? So again, we're going to picture this bucket of money, that trust fund essentially, where the beneficiary is the sole trustee of it. So your son or daughter can be the trustee of their own trust fund. They get to spend and invest the assets however they wish because they are the trustee. And because the assets belong to the trust and not to the individual child, when a creditor comes along, those assets are not under the child's name for the creditors to attach to or the spouse to attach to. So it's a really significant planning tool that a lot of our clients have already implemented in their trust. And when we when I say implement it, we don't necessarily create a whole new folder for your children to create a trust fund for them. Instead, when you come in to see us, we amend your existing trust so that when it comes to the provisions regarding what happens to your assets upon your death, it doesn't say that they just get their shares outright. Instead, it says the shares are to be held for them on the following terms and conditions and held in trust for them as follows. And so we amend your existing trust to create these protective provisions, and it has long-lasting and lifetime benefits for the children in doing so. So it's one of those things that a lot of clients already have. If you think you have it, wonderful. If you don't know, come in to see us and we can discuss this. Another reason why people set up trusts is not just to avoid probate. It's not just to deal with spendthrift or minor beneficiaries. It's to deal with retirement assets. And retirement assets are very different than most of the assets that you currently might own. Very different from real estate, very different from your checking and savings accounts or your CDs, because retirement assets generally are taxable. IRAs, traditional IRAs, and 401ks, those are taxable as they're withdrawn. And so we find that for a lot of our clients, their IRAs tend to be one of their most significant assets aside from their home. And in being so significant, we know that when you reach 70 and a half, you have to start taking withdrawals from your IRAs, and you have to start paying the income tax on what you withdraw. But similarly, when you pass away, leaving this, for many of our clients, hundreds of thousands of dollars worth of IRA money to your loved ones, your children, they too have to pay income tax on what they withdraw. But what normally happens when you die and you leave a $500,000 IRA to your son or your daughter? Do you think that they decide to, treat that as a lifetime IRA and just take out it, just tidbits each year after your death, or do you think they take it out in a lump sum? Most of them take it out in a lump sum because it just makes sense to get it over with, close out the account, take what they want and pay taxes on it, and now they're left with a nice sizable amount. But they're not left with $500,000. They're left with maybe half of that because it's all subject to income tax once they withdraw it. And so from a tax perspective, that lump sum option is awful. It's the worst option that they can elect. But for many of our clients' children, they just do so, whether it's because they lack seeking proper advice, or they just, it feels better to get a nice sum of money versus $5,000 or $10,000 per year stretching it out over their lifetime. Even though stretching it out over their lifetime will result in a much greater net benefit to them by the time they've reached retirement age. So many of our clients, not wanting to risk their children selecting the lump sum option, will create a trust specifically to hold their retirement assets, and this trust will say, this IRA money is entirely for my child or for my children. They are to get the full benefit of it, but they are to take it out on a schedule based on their life expectancy. And you know what that does? It allows the taxes to defer over their lifetime. It allows the interest to compound. It allows them to take out just the minimum amount yearly, and perhaps even more if they needed it. They pay the income tax on that minimum yearly distribution, but by the time they reach life expectancy, that IRA that we're going to use a 40-year-old child, that IRA that 40-year-old child stretched out over their life expectancy has served them a benefit of upwards to tenfold by the time they've reached their 80s, versus taking out a $500,000 IRA and being left with half of it in a lump sum option. So IRAs are something that we plan for through the creation of a standalone retirement trust. Think of it as being a separate bucket designed to hold just the IRA money. And some of the things that it does is it avoids the children from taking the money out in a lump sum. It also, one of the things a lot of people don't realize is when you name your children as direct beneficiaries of your IRA or 401k, generally they are required to name their spouse as the primary beneficiary of that asset. And for some of you, that might be fine. You might love your daughter-in-law or son-in-law just as much as you love your own children. But for other clients, that's not always a desired or intended result. They don't necessarily want to see that money leaving the bloodline. And so through the creation of a standalone IRA trust, we can also avoid the assets going to an in-law. And lastly, creditors can attach to those IRA assets that you leave directly to your children via the beneficiary form. And again, through the standalone IRA trust, we can avoid creditors from being able to attach to those assets. So if you have significant IRAs, many of you already have an IRA trust. If you don't and you have significant IRAs, this is a really critical tool to utilize and to have in place. Pet trusts, I'm just going to go over this one pretty quickly. In addition to avoiding probate, a lot of our clients have pets that they love dearly and they want to provide for. Not necessarily in lieu of their children, sometimes in lieu of their children, but these are people's, little kids sometimes. And we are able to create trusts that provide for those pets. Now, pets don't have the longest life expectancy, so when we're creating these trusts, there are a number of things that we have to work with the clients to figure out. But some of the things we address are, who will be the caretaker for the pet? How much money are we going to set aside for that pet? What types of expenses is that money going to be used for? What happens to the remaining funds after the pet's died? So you can see how we can get really creative in creating these types of trusts, and we can address all kinds of problems, and we have all kinds of solutions. And then lastly, a really big reason why people set up trusts might be to avoid the estate tax or to reduce or eliminate any estate tax liability. And I'm going to start off by just giving you some background on the estate tax. So every single person in this room has something called an estate tax exemption. And think of that as being like a coupon. We each have a coupon of $5.49 million. And we can leave that amount to our loved ones completely estate tax-free, gift tax-free, and inheritance tax-free. But the moment you leave your loved one anything above and beyond $5.49 million, there is an estate tax, also known as a death tax. And that tax rate is 40%. So in order to avoid that estate tax or death tax being paid to the government, we can create a trust that allows both spouses' coupons to be used. So for a married couple, we can allow $11 million to pass to our children totally tax-free. Now, I'll share with you, less and less of our clients have a tax problem these days. I'd say the vast majority of our clients are not people who have taxable estates. But not very long ago, that $5.49 million exemption was as low as $600,000. In the year 2000, it was $600,000. That was the maximum amount you were able to leave to your children tax-free. Anything above that was subject to the estate tax. So as a result, a lot of people started setting up what's called an AB trust, which is a pretty sophisticated type of trust, but the essence of it is it allows both spouses to utilize their credit of $5.5 million. So through an AB trust, we can leave $11 million tax-free to our loved ones. But AB trusts can be complicated. They're not for everyone. And a lot of people still have them today because of the tax laws being $600,000, 15 or 20 years ago. And as we're seeing those trusts, we're advising people to get rid of them because there's just not much use for them or need for them if you don't have a large taxable estate. But my point is, these AB trusts are used to avoid the estate tax. One of the neat things that happened in 2012 was the IRS passed a law known as portability. And portability is a law that says, it's not fair that only these people with these fancy trusts get to double the exemption amount and leave double the amount to their children tax-free. This should be a benefit available to everybody. And so now, when your spouse dies, as long as you make a special election on a special tax form known as Form 706, as long as you elect what's called portability, you are literally able to preserve your deceased spouse's coupon of $5.5 million, and you get to keep that so that in the year of your death, you have your spouse's credit plus whatever your credit is to leave to your loved ones tax-free without having any form of an AB trust. So portability has been a nice tool that has really reduced the need for so many AB trusts. And right now, we're going to kind of segue into the incapacity part of this presentation. And Jim's going to talk to you a little bit about what happens as parents and loved ones start aging, but not necessarily able to manage their affairs as much. And then I'll be back up to talk about the administration upon the passing. So thank you very much.
Thanks, Holly. Before we go on to this, I'm just going to very briefly share with you that we try to stay on top of the laws as they are right now and what we see as laws coming down the pike. And if everybody, I assume, knows that in the last 2 weeks or so, there's been some discussion about completely revamping the tax code. And at one point, Donald Trump was proposing to do away with the stepped up in basis. And that would be a huge hit for a lot of people because when somebody passes away, everything that they own gets a stepped up in basis, and you don't have to pay capital gains tax. That's not in the newest proposal. What is proposal actually is to do away with the estate tax completely. I'd say, whew. It turns out that 99.0, it's 99.8%. I'm not getting it right. I think it's 0.2% of the people who passed away in 2015 paid any estate tax. So it's such a small group of people that it's not really a big deal. And for most of us, we have estates under we have estates well under 5 million or 11 million. One of the things, though, and I don't think it's going to get passed. I'm a news junkie, and so I don't personally think can get anything passed through the Senate right now. But there is a strategy you might want to talk with your tax person about prepaying your property taxes in 2017, because right now what you pay to the state, property taxes, etc., is a tax deduction off of your federal income tax. If they did happen to pass the law and it goes into effect, you possibly won't be able to deduct it next year. So rather than just paying the first installment, you might consider paying both installments in 2017. Just another piece of free legal advice but we're really trying to figure out how to make things work for you. With that said, what we're going to be talking about is incapacity. And I have a slide here that talks about the degree of, a lot of people lose capacity. It's not Alzheimer's. But this particular slide is dealing with Alzheimer's. And part of it is that my dad, when he passed away, he had fallen on a Saturday and had a major hemorrhage and went into a coma and passed away a week later. But before he had fallen, he was driving, he was mowing his lawn, he was in his 90s, he was lucky on her pass out of here. My mom suffered from Alzheimer's for about 7 years following her passing. And I mean, before her passing, I'm sorry. And so for 7 years, I was tasked with making sure my mom's bills were paid. Initially, the water bill, the electric bill, garbage, taxes, etc. And it turns out that right now they estimate about 1 out of 8 people in the United States have Alzheimer's, about 5.2 million. But in approximately 13 years, they're estimating that to be up to 7.7 million people. So the problem, part of it is that the baby boomers, as we mature, get older, that they're concerned. And it's not just Alzheimer's. It's dementia. It's a variety of other issues. And the thing that I noticed is, first of all, the court has a plan for those that don't plan. Just like Holly mentioned that everybody has certain plans and so forth. Well, the court has a plan called a conservatorship. And to the best of my knowledge, out of my 10,000 clients that I've been involved with helping avoid probate, etc., only 2 of them have ever had a conservatorship imposed. One of them was kind of a sad situation. It was a gentleman that lived in Westminster, and his daughter, his only heir, was living in Texas, and because of Dad's diminished capacity, transients had moved into Dad's home and was kind of taking over and so forth, and kind of moving Dad further and further out. And so the daughter from Texas arranged for somebody to go into court and get a conservatorship appointed over Dad. When she got basically finishing up with the conservatorship, they looked at the title to the property, and that's when they realized that there was a living trust. And if the daughter had known that there was a living trust, the trust would have allowed for the daughter to do the necessary functions without having a conservatorship. Now, this may just have been the size of the estate. It may have been other circumstances. But the gentleman only lived 6 months while the conservatorship was going on. A third of his estate was gone. When I say it's expensive, that's been my experience. And so generally, again, when you're out to dinner, say thank you. And actually with this one, you might not want to say thank you because, believe me, being the trustee and so forth that's dealing with it, it's a headache. I was really felt like I was running two people's lives. I had to make sure my bills got paid, and I had to make sure my mom's bills got paid. In case, just a practical side, what I did when my mom's situation was I had all of her bills being paid automatically so that it just came right out every month. I recommend that because they never shut off the electricity, so life was good. Very expensive ongoing supervision by the court. The trust avoids a conservatorship, just like the trust avoids probate. Remember I said at my passing or my wife's passing, my kids get a death certificate and they can go to the bank? Well, they don't get a death certificate because if mom is still alive, they're not going to get a death certificate. But what they get is two doctors' statements saying that mom has lost her capacity to act. And in the trust it says if there's two doctors that say mom has lost their capacity, then the successor trustee steps in. And now the successor trustee is managing the assets and paying the bills exclusively for mom's benefit without going into court and having a conservatorship. So more difficult for the successor trustee. What I mean by that? Generally when somebody passes away, you might have 1 or 2 months of paying the water bill, 1 or 2 months of paying the electric bill, the telephone ends, the television ends. With when you're acting as a conservator, you're filing tax returns, you're filing property taxes, you're dealing with water bills and so forth. And in my mom's situation, my mom ended up going into a boarding care facility, so I had to be paying for that. There was a lot more time involved and just more challenges. You write more checks, enter into more contracts. Takes two doctors' statements and the trustee that basically says that mom is not capable of acting. One of the things that you do as the successor trustee is you literally are the person's agent. And as an agent, you're going to be the one filing income tax returns. You're going to be the one dealing with all of the issues that comes up. And when mom ceases to be the trustee of her own trust, at that point, you need to get a tax ID number for the trust because mom's Social Security number will no longer work if she's not a trustee. So one of the strategies that we use a lot of, and this is part of why I want to bring it up when I have the next generation here, is that if you see your loved one starting to develop memory loss and some confusion, rather than waiting until it's a crisis, because if it's a crisis, we have to get a tax ID number, we have to file a special tax return. Instead of waiting for that to occur, what can happen is that you could put your daughters on as a co-trustee with you, and as a result, if you put them on as an owner, and your daughter was involved in a car accident, got sued, went through a divorce, your daughters could lose your assets. Not a good idea. But they're not the owner, they're just the manager of it as being the trustee. And what we sometimes do, we'll put daughter's name on with mom so that they're co-concurrent trustees. We still use mom's Social Security number and we still file the same normal 1040 tax return that mom always files. The only difference is that daughters are now with mom, but if anybody gets sued or whatever, if the two daughters get sued, their creditors can't take mom's assets because they're not the owner, they're just the manager. This does not prevent the trustor from still acting but allows for somebody to assist them. That's the whole concept. The benefit is protects the assets in case of additional trustee is sued. No taming of the tax ID number. We don't have to file a special 1041 tax return for a trust. I do want to caution, and I want to emphasize this. The disadvantage is that if you are named as the trustee and you start thinking that, well, mom really doesn't need all that much money, so I'll just kind of help myself to a little bit and, take a little bit more and a little bit more, we got a problem. The trustee violating the fiduciary duties, if you notice, that one's in jail. It turns out that there's a term that we use in law school, tort. Is there anybody that's not familiar with the word tort? Okay. The tort is basically a civil wrong. One of the prevailing civil wrongs that's getting bigger and bigger is elder abuse. If I had taken my mom's money when she had developed dementia and started benefiting Jim Roberts, not mom, if my siblings or somebody else found out about that, they could bring an action against me, and let's just say that somehow I had misappropriated $100,000. I'm not responsible for the $100,000. I'm responsible for $300,000. They make you pay 3 times treble damages. And so one of the things I want to emphasize is if you are named as the trustee, the trust is designed for mom's benefit while mom is alive. You can't use money. And I'll share something else. What so often happens is that we start to put our mom is kind of fading, so we start writing checks for mom, and we've kind of slowly fade into the position. Well, mom doesn't care what you're doing. Mom knows what's going on. She's happy. But let's say that you go 6, 7, 9 years helping mom. Nobody has a right to look at what you've been doing. Mom does, but nobody else in the family. But after mom passes away, your siblings or the other beneficiaries have the right to say, okay, from the day that you stepped in 9 years ago, we want a counting of every dollar that's come in and every dollar that's gone out. And oh, by the way, if you can't prove what went out and it was for legitimate purposes, guess who's writing the check to make up the difference? So I would emphasize the idea to make sure that when you are acting as the trustee, you keep good records, you document it. The worst thing you can do is deal with cash. We had a client that was not our client, so it was not something I would have encouraged her to do. We didn't know the client until mom had passed away. But a client, apparently, mom liked cash. So the way she did it was every week or whatever, she'd go to the ATM and she would just get cash. Well, there was a time period of about, 8, 9 years that mom had diminished capacity. Daughter was acting as the trustee, and mom and daughter went and got cash. Guess who had to write a check for basically all the cash because she couldn't prove that it was used for mom's benefit? And I'm not positive, because Holly and I was talking about that earlier today. I'm thinking it was around $180,000. So I want to emphasize, just keep records, document. It's not as 99% of the time, more than 50%. Let's go there. I'm going to start with a low number. More than 50% of the time, people are not going to steal their mom and dad's money. There are some people who will, but most people won't. But it's not, what?
Are there any guidelines where you shouldn't be doing this? I mean, guards, it may be too late by the time you get down.
The gentleman's question is there any guidelines? First of all, hopefully when we were sitting down and talking about who should be the trustee, we chose people to be the trustee that are trustworthy. I absolutely, and I'd say this, I truly believe that my parents could have given me $1 million, put it in my account, and I would not have misappropriated the money. I would not have done anything. And I really do believe that that's where most of my clients' children come from. But I'm here to tell you that I've been practicing for 36 years, so I've seen the good, the bad, and the ugly. And I'm going to share something I don't want to share too much because the person didn't give me permission. But we hear so much about the ugly. I had a client this year who inherited $1 million. He was not wealthy, and he felt that that really was not his, that belonged to his step siblings, and he gave them $1 million. Person of character. Not very many people did it. He could have taken any of it or all of it. He took none of it. So there are, and I do see it, I have seen families go out of their way to treat other people fairly, etc. But at the same time, aware that there are some that don't. And so it's just like the family in which do I really think that the daughter embezzled $180,000 from her mom? No. But if you can't prove it, you're held liable. So the whole idea is to keep the trustee document. And you'll do it because you're here today and you're learning about that. The next part that I just want to cover is about Medi-Cal planning. And when I'm talking about Medi-Cal planning, I'm just going to be introducing the subject. And the reason why I introduced the subject is, let me give you an example. I had about 30-some years ago when I was first setting up trust, I helped a woman, and if I'm not mistaken, her name was Betty. She seemed to be very young, very vibrant, very capable. And about 6 months apparently after I'd set up her trust, she was going through a parking lot and she tripped over one of those cement blocks that you bump your tire up against. When she tripped, she fell and broke her hip. After the surgery, she went into a nursing home, and then one complication after the next, and here was this woman, I think she was in her 60s, that spent the rest of her life in a nursing home. What happened was that after Mom fell, broke her hip, about 2 years later, I get a phone call from her daughter. And her daughter says, and her daughter for the first time explained to me about Mom falling, breaking her hip, and said, Jim spent her savings. We sold her home. We now have the proceeds from the home down to $2,000. Can you help us qualify Mom for Medi-Cal? And the answer is, I can do that. No question. The tragedy was, if somehow the daughter had called me 30 days after Mom had fallen, we would have saved her savings, we would have saved her home. Because I jokingly say there are two types of people who qualify for Medi-Cal. Those that are truly poor and those that have good attorneys. So let me kind of explain before we go into the details here. I'll just give you a test. Let's say that it's a husband and wife. They live down on the Balboa Island. They have a beachfront piece of property. We'll just say it's $5 million, $11 million, it doesn't matter. But let's say a $5 million home. They have a Rolls-Royce car. Everybody has to have a Rolls-Royce to get to the grocery store, of course. They have the husband has quite a bit of money in savings. We'll say $2 million in his IRA, 401k. And they have $100,000 in their checking account. How much does that client, let's say one of them, doesn't matter whether it's the husband, doesn't matter whether it's the wife, but one of them has to go into a long-term nursing care. How much of those assets do they have to get rid of in order to qualify for Medi-Cal? All of it. Is that what I heard? The right answer is none of it. They qualify for Medi-Cal. And that's the problem. People don't understand it. So today I'm going to just introduce it. But let me go back and explain. A home does not count as an asset for Medi-Cal purposes. You can have a home of any value. IRAs, 401ks do not count as an asset for Medi-Cal purposes. You can have any value. A married couple, they allow you to have approximately $120,000. And a car of any value qualifies for Medi-Cal. Now, I would share with you that I know of people who, how they were getting rid of their parents' assets or somebody's assets is that the parent would buy a Rolls Royce on Monday and give it to their daughter on Tuesday. That was an exempt asset, so that was okay. And then they would buy another Rolls Royce on Wednesday and give it to another child on Thursday. And you could see, get rid of $300,000 at a crack, giving money to, situation. I've never had anybody buy a Rolls Royce to qualify for Medi-Cal yet. But I will share something with you. A car is an exempt asset. If my mom has never driven, she would still be entitled to a car. A strategy that I have had clients do, a 65 convertible Mustang. Why? Because if you go out and buy a 2017 Lexus and drive it off the lot, it goes down in value. You buy a 1965 convertible Mustang, when mom passes away and you sell it, you hope that it, worst case, is you get as much as you paid for it. But in reality, there's a chance that it will go up in value, but a car is considered a car. So be aware that there's some planning strategies. Allow the successor trustee to be aware of the planning opportunities. We're not going to fully explain it in the course of 5 or 10 minutes, but Medi-Cal is not Medicare. Bill Gates qualifies for Medicare. Anybody over the age of 65 that paid into Social Security qualifies for Medicare. Medi-Cal is for people who, it's the same as Medicaid. 49 states call it Medicaid. We in California call it Medi-Cal. It's up to 85% of all Medi-Cal, Medicaid is paid by the federal government. So it's not a state-funded, state-ran program. It's a state-administered program with generally federal funds. And it's the only program that's the government program that provides for long-term nursing care. There's 3 aspects of Medi-Cal planning. First, can we get a person qualified? Second, how much does the person have to pay, the family, and how much does the government pay? And then third, in the past, it's been how much does the government collect when you pass away? Most people understand that if you have a loved one that's on Medi-Cal, when that loved one passes away, you get a bill for every Band-Aid, every aspirin, every shot, and it's not unusual to get a bill of $163,414.52. So it's kind of like you win the battle and lose the war. As you're going to see, the law has changed in California. So the Medi-Cal planning is your residence is exempt, 1 car, IRA accounts are exempt. If you're married, you can have $120,000, and if you're single, they allow you to have a whopping $2,000. But every year they publish the cost, and up here this is the correct number. Your slide had it for last year. I think it was $8,400 some dollars. Now it's $8,515. Let's just say, for the sake of discussion, that my mom had $1 million in savings, and my mom is in or needs to go into a convalescent home. If we were to call up social services, and we'll say that my mom is a widow, if we were to call up social services and say, my mom has $1 million, how do we qualify her for Medi-Cal? Social services would say, spend $998,000 on your mom's care, and when you get that money down to $2,000, call us. That's possible. That would be a way of doing it. But let's assume on November 1st, my mom transfers to me $8,500. Why is that $8,500? It's actually $8,515. She transfers to me the average cost of staying in a nursing care. That $8,500, that totally disqualifies her for the entire month of November, because that would have paid for 1 month in a nursing home. Got that? But on the 2nd of November, my mom transfers to me another $8,515. Instead of being disqualified for 2 months, the way California interprets the law, if it's done in the same calendar month, it only counts as one transfer. On the 3rd, the 4th, the 5th, the 6th, the 7th, the 8th, the 20th, 21st, 31 days in November, my mother has transferred, I guess there's only 30 days in November, sorry about that. 30 days turns out to be $256,460 that my mom can transfer in 1 month. And how long is she disqualified for? 1 month. But remember, I have 3 siblings. On the 1st of November, my mom transfers to me transfers to my brother $8,515, my sister, my other brother. End result is at the end of a month, my mom has transferred $1 million. It's transferred in a way that there's absolutely no tax to the recipients, no tax to the donor. And how long is my mom disqualified for? Come December 1st, she applies for Medi-Cal. On the form, they say, have you made any gifts in the last 30 months? And the answer is yes. And then they say, if yes, please describe them. On the 1st, I gave to James F. Roberts $8,515. The 2nd, the 3rd, the 4th, they say, okay, thank you very much. Now, it doesn't seem fair, but if my mom had given me $256,000 in a lump sum, she's disqualified for 30 months. Doing it on a daily basis. And that's one of the questions I think sometimes. It was a gentleman at the end of the last session says, can my children do this alone without coming in to have an attorney help them implement it? And my opinion is kind of yes. I just don't recommend it, because there's enough little things that you just don't know. So $8,500 per day, can transfer hundreds of thousands of dollars if done in 1 month, only be disqualified for that month. The real planning is to prevent assets. That's what it's always been in the past. But as of January 1st, 2017, it is the law today, if at the person's death, the person that was in a convalescent home that was being paid by Medi-Cal, if their assets avoid probate, the state doesn't recover anything. Did I mention how a living trust avoids probate? Guess what? For those of you who have a living trust, if you had to go into Medi-Cal, you now do not lose your assets to the state. They still keep track of the Band-Aids and the pills and say there's a bill for $163,000. You're just not responsible for it any longer. Pretty amazing. And so that's the new law. It shocks me because it's going the wrong direction. California has financial difficulties without this, but that's what got signed into law as of January 1st. It's the Senate Bill 833. And that brings us now to the real part, and that is where we're ready to be talking about how to implement the estate plan when a person passes away. And that's, Holly's coming back up. Since I've been talking here for 15 minutes waiting for her to come up, she just walked in the room right when I finished.
A lot sooner than you normally do.
Okay, here we go, Holly.
Thank you. All right. So the natural progression things Jim just discussed in capacity is Yes, people are living longer lives, but not necessarily healthier lives. So there are a number of things we can do to help in that incapacity period. But when it finally comes time where the person who's created the trust has passed, we now get to that trust administration process. And trust administration, it can be called a number of different things. Sometimes we call it winding down a trust or closing out a trust, but legally we refer to it as trust administration. And this is where there's a lot of mystery behind what exactly happens after a person dies. How do we actually transfer everything over? What are those steps involved? And it might feel a little overwhelming to hear about all of these legal things because there's things that you might never have even known are requirements. But the idea is we just want you to get just familiar with it, just have some exposure to it so that it's not like you're being thrown into this for the first time in a crisis mode. So that exposure is important. And if you take even just tidbits of this with you, it's going to be helpful. So the trust administration process, we've tried to kind of condense it to a nutshell and have 10 really main things that we think it boils down to. And we're going to expand on each of these 10 things. The first of which is a copy of the death certificate. And I start with that because when a person passes away, actually, it's not like the death certificate immediately arrives in the mail. The death certificate is handled usually through the mortuary or whoever is whatever company you're working with for the burial or cremation services. They will be the ones who, on your behalf, will order death certificates. Now, why is the death certificate so important? Why do we start with this as the starting point? Because without a death certificate, you can't do anything. You can't get anything done. You can't prove that your role as a successor trustee has kicked in because nobody's going to give you access to the trust assets or mom and dad's trust accounts if you can't show that they've actually passed away. The banks want proof of it. The county recorder's office wants proof of it. So the death certificate is the first step in being able to gain access to the assets to carry out your duties as a trustee. So very often clients will call us the day mom or dad pass or the next day and urgently they want to come in and they want to just start taking on the role and doing what they have to start doing. And we tell them, it's okay. We don't even want to see you right now. You need to be with your family. Take this time to grieve, to be supported by your loved ones. There is going to be plenty of time to do what you have to do, and there's a lot to do. And you're going to feel overwhelmed by the paperwork and dealing with the banks and, mailing things back and forth. There's going to be a time and place for that. But those first couple of weeks before the death certificate arrives, we encourage you to just take it easy and don't worry about all of the legalities yet because truly you can't really do anything anyway. So 2 to 3 weeks is the time frame for a death certificate to arrive. How many death certificates you need really is going to depend on the trust, on the estate of the person that you're administering. I mean, I would say at the very minimum 4 or 5, but I've had clients who've needed more than 20 of them. And it really just depends. Some banks will accept a photocopy, which is nice because you don't have to waste a $21 death certificate. Other institutions will insist on a certified copy, the $21 copy. So depending on how many bank accounts or investment accounts, how many different assets the person left behind, you'll get an idea of how many death certificates you should order. It's always better to over-order, I think, even just by a few, because if you have to, if you run out and now you have to suddenly wait a few more weeks to order more, it just doesn't work out very well. So I'd say at the very minimum 5 or 6, but in this period of time, if you are one of those trustees who is truly eager to get the ball rolling and just you want to fulfill your duties and you want to start taking care of business, even though you can't legally start accessing the assets yet, what you might do is start taking an inventory, start figuring out where are the bank accounts, where are the investments at, checking the mail. I mean, you can always forward the mail during this time, so that's a productive thing to do. During this time, you could change the locks. That's another thing you can do because remember, as the trustee, you're going to be tasked with securing all of these assets. And if there are multiple people out there who have keys to your parents' home, you want to secure that home. And changing the locks would be appropriate. Forwarding the mail would be appropriate. And starting to look for those assets, even if you don't have a complete list. You can't get a complete list or know exactly what everybody has within a week, but you can start that process of inventorying, even if you don't have a death certificate yet. So when I say there's not much time sensitivity and you can take a few weeks of time to yourself to kind of get your bearings straight, there is definitely some time sensitivity involved in a trust administration. We don't want you to just sit on it and say, oh, I've got all the time in the world. You don't have all the time in the world, but those first few weeks you can take your time with. The first most time-sensitive requirement in a trust administration is the filing of the person's will. So California does have a legal requirement that within 30 days of death, the will of the decedent, which is also contained in this folder, so your trust is in this book, but your will is also in this book, under one of the other tabs. That will has to be filed with the clerk of the court for safekeeping. It's not like we're starting a probate or we're petitioning the court to wind down your estate. The court's really not involved. California just has this safekeeping rule. And they say if you have a will, your trustee or your executor has to file that will in a vault for safekeeping within 30 days of your death. So it is time sensitive. The other time sensitive step is the legal notification requirement. As a trustee, you have to, whatever the date of death is, within 60 days of that date of death, you have to deliver a very legal notice to the beneficiaries and heirs of the person who just died. And this notice, it's not a really friendly notice. It doesn't arrive in the mail saying, my sincerest condolences, please accept, my apologies for your loss. It doesn't say anything like that. It says, this person died, they left a trust, you're entitled to a copy of the trust, and you have 120 days to challenge the terms of the trust. So it doesn't come across very nice. And you can imagine if you're on the receiving end of this notice, you might start having questions as to, oh, do I need an attorney? Should I be challenging this trust? And so it does raise some questions, but as a trustee, you don't have a choice. You have to send this notice off. And the reason why you have to send it off is not just because the law requires it, but it's in your best interest to do so. If you don't send it off, and you just decide, oh, we all get along, everybody knows what the trust says, I'm just going to give everybody their inheritance and we'll all go our happy way. 10 years later, 20 years later, any one of those people can now contest the trust. And they can contest it because you never closed or wound down the period of time to challenge the trust by sending this notice off. What this notice does, the moment it's delivered, it starts the clock to tick on 120 days, which is how long the individuals will have to challenge the terms of the trust. And that gives you a whole lot of peace of mind as a trustee because you now know 120 days after that notice is delivered, nobody can challenge the trust. You can disperse the money and you don't need to worry about a lawsuit being filed and you left holding the bag because you've dispersed all the money already. So this is a really important requirement and it has to be delivered within 60 days of the date of death. Who actually gets the notice? Any person who's named as a beneficiary of that trust. If you've named the OCSPCA, or if you've named your son or your daughter, if you've named 2 of the grandkids, all of those people who are named in the trust are entitled to a copy of this notice. But if you've also disinherited your heirs, so if your natural heirs have been disinherited, maybe you left everything to your grandkids and you disinherited your 2 children. Your children, even though they're not beneficiaries because they're not getting anything, they are still considered your heirs and they're entitled to this notice as well. So as the trustee, you have to figure out who are the heirs, who are the beneficiaries. They're usually the same, but sometimes they're not. And a notice has to be sent to each of them. The inventory and appraisal of assets is so important for so many reasons. As the trustee, you are the one that is responsible for marshaling everything and gathering all of the assets. And for a number of reasons, you need to know what the estate consists of. And it turns out that there's not like a central registry or database where you can just plug in your parent's name and figure out what all of their assets are. There's no one central location that contains all of their bank account info and real estate and asset info. There isn't. If you are not one of those lucky people whose parents haven't made a really organized list for you, you're going to have your work cut out for you. You're going to have to monitor the mail. You're going to have to look through bank statements. You're going to have to look at their income taxes to see what kinds of assets they had. And sometimes that's really tough, right? Because they might have I can't tell you how many life insurance policies go unclaimed, $5,000 policies or $10,000 policies, because the parents just never listed it and the kids just don't know it exists. And when they call us and ask us, well, don't you know what mom and dad's assets are? Remember, we don't see our clients quarterly. I mean, we get to see you hopefully yearly at events like this, but we don't make a list of all of your assets. And when we meet for the first time to set up your trust, we'll try to be as thorough as possible about gathering your asset information. But that information changes over the years as you close out accounts and you open new accounts and you sell real estate and you buy new real estate. So we will have some information and hopefully be able to guide you, but the bulk of that inventorying and appraising of assets is going to be done by you, and that legwork is going to be done by you as a successful trustee, and hopefully your parents are good about keeping an up-to-date list of their assets, which if you haven't had that conversation already, maybe this is a good reminder to go home and make that list, because otherwise it's really hard to find that information. But tax returns and monitoring the mailbox is the two key ways that kids find it. Why do we need to figure out what all of the assets are? I mean, do I even need to explain it? There's more to it than just knowing what the size of the estate is. It turns out that anything that you own at the time of your death gets a step up in basis, which is a really neat tax effect. And that is, at the time of your death, if you owned a property that you had previously purchased for $100,000, like my parents' home in Anaheim Hills. They had bought it for less than $100,000, and today, 30 years later, it's worth almost $700,000. That property, if they are alive today, if they try to sell that home, they will incur a capital gains tax, because the difference between $100,000 and $700,000, the IRS sees that as gain or income, and it's taxable. When they die, that basis of $100,000 steps up. It adjusts to whatever that property is worth on their date of death. So my brother and I can turn around and sell that Anaheim Hills home. If it's worth $700,000 on the date of their death, we can sell it for $700,000 and pay nothing in capital gains tax. But to get that basis update, we need to document in writing what the property is worth on the date of death. And that can be done through an appraisal. So as a trustee, you should be getting an appraisal on the real estate. Or if you don't really want to pay for an appraisal, sometimes you can ask a realtor to do like a market analysis or just a sales report of what that property is worth on the date of death. But it's really important for when you turn around to sell it. Another reason why you need to know what the estate is worth is because we need to know what the size of the estate is for distribution purposes. The trust usually, it's drafted in a very timeless sense. The trust document doesn't say my Wells Fargo account will go to you, my real estate in Anaheim Hills will go to you. It just says everything in the trust is to be divided as follows. Maybe it's 20% to this person, 10% to this person, 30% to that person, but you don't know what that percent is until you know what the dollar amount of the entire estate is. So you have to figure out what the overall value of the estate is by appraising everything, coming up with date of death values so that you can properly distribute everything to beneficiaries. Another reason why you have to inventory the assets is to determine whether there's any estate tax liability. Estate tax liability, I think we might have touched on it briefly. $5.49 million is the amount that you can leave tax-free to your loved ones. If we have more than that, there's going to be a 40% estate tax owed to the IRS, due within 9 months. So we need to know what the value of the estate is to see if there needs to be something done about that. And then lastly, there's an accounting process. As the trustee, no matter how trustworthy you are, most beneficiaries aren't just going to take your word for it that, the check that they got in the mail is full satisfaction of their share. You have to actually show an accounting of every dollar that's come in, every dollar that's gone out for expenses and so forth, and show how you got to the number that you got to and how they got the check that they received. So that accounting process is pretty tedious. As a trustee, you have to account at least annually to the beneficiaries, and more often if they request it. I say this, when I say the trustee has to account to the beneficiaries, very often the trustee is one of the beneficiaries. So if mom named you as a trustee, you're probably the trustee for, yourself and your siblings as beneficiaries. If there's a really harmonious situation among everybody, that accounting could sometimes be waived, but you can't really count on that. And so you want to be prepared to have an accounting thoroughly done from the get-go until and unless all of the beneficiaries waive it. Then we get to the tax ID number, which is another requirement to administer the trust. When a person dies, their social security number, it expires. It can no longer be used to register their assets at the bank. The banks can't use that social security number for purposes of identifying their accounts and investments and so forth. And so when you step in as a successor trustee, you're not going to give the bank your social security number because these assets don't belong to you yet. You're wearing the hat of a trustee. You're just holding on to these assets for the benefit of multiple beneficiaries. So your social security number wouldn't be the appropriate number. Instead, you apply for this neutral number. It's a tax ID number, and it takes us maybe 10 minutes to apply for that number online. But with that, with the death certificate and with a copy of the trust, you as a successor trustee can now gain access to all of those trust assets so that you can start paying the bills, paying for the expenses, and then when time comes, distribute the assets to the beneficiaries. And so, already kind of alluded to this, the tax ID number is a critical step in gaining access to those accounts, to the investments, to the any of the assets that are in the trust. And I say here that the trustee doesn't personally own the assets at this point, but they are holding those assets in a fiduciary capacity. You hear that term a lot, fiduciary, fiduciary. As a trustee, what a fiduciary means is somebody who is tasked with looking out for the best interests of somebody else. And that's what you're doing as a trustee. You might very well be one of the beneficiaries, but above and beyond everything else, you are first and foremost the trustee and wearing the hat of a trustee. And so you have to put others' interests ahead of yours. And as you're going about retitling the assets, you're going to find that there are different types of assets. There's real estate, there are bank accounts, there is investments. And so I wanted to shed some light on the different approach to how you gain title to real estate and how you gain access to bank accounts. Real estate is a slightly different process because there's no financial institution where you can just walk into it and say, okay, please retitle this account into my name. Real estate is a matter that deals with the county recorder's office. And so through the recorder's office, in order to get your name on title, we file something called an affidavit of death. And what the affidavit of death does is it's almost like a grant deed. It removes the deceased person's name from title, and it tells them that they've died, that a death certificate is attached, and that you are the successor trustee. When we do that, you go on title, and you can now sell the home if you need to. You can deed the home out to a beneficiary if that's what the trust calls for, but you can start conducting business on behalf of the home because the affidavit acts like a grant deed. Whenever we change title to property through the affidavit, we're always looking out for Prop 13 as well. If it's a transfer, if the trust involves a transfer of real estate between a parent and a child, and in limited circumstances between grandparents and grandchildren, we are able to preserve that Prop 13 tax rate for those children or for the child who's taking the home. So Prop 13, if you're not familiar with it, is a law that is what allows your property tax rate to be based on what your home was purchased for and not what the value of your home is today. So my parents, whose home is in Anaheim Hills, they're paying less than $2,000 per year in property taxes and not the $10,000 that a newly, purchasing person in the neighborhood would be paying. That same property tax rate passes on to your children as long as special forms are filled out and sent to the assessor's office, and we will help you with that process. Bank accounts and investments, slightly different process. Those are going to be where you go to the financial institution, you present the death certificate, you present the tax ID number, you present a copy of the trust, and now your name is on that account so that you can start administering it and you have access to it to carry out the provisions of the trust. Another aspect of trust administration involves filing of tax returns. And generally, there's 3 different forms that we're concerned about in any trust administration. Not all of these are going to apply, but the first one is one that doesn't come into play often unless we're dealing with a particularly large estate, and that's IRS Form 706. If, like I mentioned earlier, we have a taxable estate of more than $5.49 million, if a person dies leaving more than that, remember, there's the death tax of 40% on anything above $5.49 million. And the death tax is money owed to the IRS, and it's got to be paid to them within 9 months of death. So not only does the form have to be filed within 9 months, but the money has to be paid to the IRS. That tax has to be paid to the IRS within 9 months. And it's determined through the completion of a 706 form. So you have to file that as a trustee. If we have less than 5.49 million, we generally don't need to worry about the 706 form. The two forms that most trustees are going to be dealing with in any trust administration is the 1040 and the 1041. The 1040 we should all be pretty familiar with. That's just our individual tax return. And in the year of our death, because you were living from January 1st to, let's just say, June 30th, those 6 months that you were alive, somebody has to report any activity or income that was going on during your lifetime for that last year of life. And your trustee will do so by filing a very final 1040 form on your behalf. And for that period of time ranging from your date of death, let's just use June 30th, to the end of the year, let's just say December 31st of this year, where you stepped in as a trustee in your fiduciary capacity, you file a 1041. So those are the two forms that you will be filing as a trustee. And you're not actually going to be preparing these forms as a trustee unless maybe you're a CPA. You're going to have a tax professional do so for you, but just be familiar with the fact that there are different tax forms involved as a trustee that you'll be responsible for seeing that they're filed. And so trustees' duties. This can be a whole presentation in and of itself, but as a trustee, yes, you have certain legal requirements to marshal the assets and safeguard the assets and get a tax ID number. But once you've gained access to all of those assets, the way you deal with those assets and the way you deal with the beneficiaries is so important. And there's a whole host of what's called fiduciary responsibilities and rules that you have to abide by. And it's all pretty much common sense. But when it comes to a trust administration, a lot of times emotions can get involved. And emotions get involved in the sense that you've spent a lifetime with, maybe your siblings and the beneficiaries who are involved in the trust. And you might have a wonderful relationship with your brother, or you might hate your sister-in-law, and you might be so livid with your other sibling who never visited mom, in the last years of her life, or another sibling who didn't even attend the funeral. There might be all kinds of emotions involved. But as a trustee, you're not allowed to have those emotions. You have to be a professional. You have to put all of that aside, and you have to just do your job as a trustee and carry out the terms of the trust just as a neutral third party would. And some of those rules that are imposed upon you are going to be the prudent investors rule, which holds that just because mom and dad trusted you to be the trustee doesn't mean that they trusted you to pick and choose any investments that you wanted to. So if your neighbor tells you about some wonderful technology stock that's about to blow up, and you go and put $100,000 on red, and that stock tanks, you are personally liable to the beneficiaries for making them whole again for that loss, because that was not a prudent investment. So it's really a common sense rule. Do with the assets as a prudent investor would do. Duty to account to the beneficiaries. We discussed that at least annually the beneficiaries are going to request an accounting, or you're going to have to provide it to them at least annually. They could request an accounting more often than that, and you will have to furnish it to them within a reasonable time frame. The accounting is really important because that's what tells them what has come into the trust, what have the expenses of the trust been, and how did you end up with the amount that you've ended up with. And this can be a real point of contention in a lot of trust administrations, which is why meticulous record keeping is so important. Duty to avoid conflicts. This can happen a lot because a lot of trustees are also beneficiaries. So mom might have named you because you're the eldest sibling, but you're also a beneficiary of half the estate. So maybe you think there's no problem saying, well, I'm doing all of this work. I should get the home at a discount because I really want the family home. That's not right, and it's not fair, and it's not allowed. As a trustee, you have to be really careful to avoid those types of conflicts. And then lastly, dealing with beneficiaries impartially. And that just goes back to all of the emotions that might be involved in a trust administration. You might have different relationships with all of the different beneficiaries, and you might be inclined to really want to help out your sister who really, really needs the money now and give her a $20,000 distribution and not give anything to the others quite yet. But you can't do that because that's not impartial. You can't be that way with the beneficiary. So you have to treat everybody equally at all times. So this is just scratching the surface of some of your duties as a trustee, but some really important duties I thought that we might share with you. And then finally, we get to the distribution of assets. So this is where the trust administration finally is coming to a head. We've learned about what are the legal steps and what are the documentations and things that we need to file in order to start gaining access to everything. But all of it is leading to one final conclusion, and that is to finally disperse the assets, to finally dissolve the trust. And here it says, after all assets have been inventoried and appraised, and after you've paid all of the expenses, it's now time to make a preliminary distribution. And why does it say preliminary distribution? Because we thought it was time to close the trust. It says preliminary distribution because you don't want to be in a position where you just disperse everything, and then a couple weeks later, a medical bill pops in, or some tax liability arises, and now you have to call up every one of those beneficiaries and say, oh, can I have some money back because I have to pay for such and such expense? So we usually will advise you as the trustee to hold back a reserve, some amount, and there's no science to the reserve. It's not like you've got to hold back X amount. It just depends on the person's estate. Maybe they have a lot of credit card debt and a lot of creditors. And for someone like that, we might say hold back 10 or 20%. But if it's a pretty modest estate and the person didn't have a ton of creditors or bills, 5% might be enough. So we'll work with you in determining the reserve amount. But you can distribute everything aside from that reserve amount. And then after the final tax returns have been paid and after you're positive there are no other creditors or debts, you can disperse maybe the following year the remaining reserve amount of 5 to 10%. And then down here it says the trustee has to be sure to distribute the assets in accordance with the trust. So if the trust says everything just goes to the kids outright, that's pretty simple. You just disperse the final cent out of the trust, and at that moment the trust dissolves. It closes. Your job as a trustee is pretty much over. But remember, not all trusts provide for that outright distribution. There might be minor beneficiaries that you have to hold the money in trust for. There might be special needs beneficiaries. So you have to really read the trust and make sure that you're carrying out the provisions exactly as the trust directs you to. But for the most part, in most cases, if it's an outright distribution, the moment the assets are distributed, your job as a trustee is finally over. So closing the trust. Just kind of spoke about that. Once the very last asset's distributed, the trust administration process concludes. But just keep in mind, this can happen in just a few months. A trust can wind down completely and the assets can be distributed if everyone's getting along and there aren't that many complex assets. But in some cases, it could take years. So it just depends on the type of trust that you've been named to administer. And with that, I'm going to ask Jim to come back up for our next steps.
All right. Thank you, Holly. We're just about wrapping it up. I figured your mind has absorbed about as much as you can take in, and probably that was about 3 hours ago. Since we've only been here for 2, we're the next step, though, I'm just finishing it up and say, for those of you that have a trust, I don't have a lot of opportunities to stand before clients that have trust and talk to them about times about reviewing their trust. I'm just going to spend a couple of minutes. You have it in your slide, but you have changes to make regarding beneficiaries and distributions. I'm just going to share that there's been some real significant changes in my life with regards to how my beneficiaries are doing and some issues that are going on. And so my wife and I changed our trust to deal with that. And so it's a situation because what was appropriate at one time is no longer appropriate at this point in time. And so you have changes to make regarding beneficiaries and distributions. Also, significant increase or decrease. Remember, a lot of you, when you were setting up your trust, it was $600,000 to be taxable. Today it's 5.5 million. 99.8% of the population do not have an estate tax obligation. But if you have had a significant increase or decrease, it might be a good chance just to review your trust. Your marital status has changed. If you get a divorce or you have a death, there really should be coming back in and making sure, because those are typically times that you want to have it reviewed. A beneficiary has become disabled or currently does or may need to qualify for government assistance. Holly mentioned about the client in which they have the pump that's costing $20,000 a month in pills. That are in medicine, and that type of thing could have been avoided by having to go into court, all of that, if it's kept up on top of the trust. A successor trustee has passed away. Some of you may have named a brother or sister or something, and your brother has developed dementia. You would not want your brother to be the successor trustee. You or your spouse have memory lapses. You or your spouse have memory never mind. And other challenges that may affect your financial institutions, financial decisions and so forth. And if you are doing that type of thing, it's really better to come in before there's a crisis, because we just have more planning opportunities. And sometimes we do nothing, but a lot of times what we do is find out, okay, we see the kind of the cards that have been dealt. Now what we want to do is just make sure that we play those cards the best that we can. If your estate plan has not been updated, or take advantage of the recent law changes involving IRAs and 401ks. Holly emphasized going through divorce, creditors, if you leave it to your children, their creditors and spouse, their in-laws get their IRAs. If you leave it for your beneficiaries in a trust, we can protect it. And then finally, for those of you that have not had your trust reviewed in maybe the last 10 years or so, it's a high probability, especially if you were married when you set up your trust, you would have an AB trust. An AB trust is generally not what most people need today, because most people have under 5.5 million. If you happen to have lost a spouse and have this B trust with a separate tax ID number, and you've been doing the steps that you should be doing, what happens is that we have been very successful going into court and having the court close down the B trust, and it has a significant tax savings, because there's a capital gains tax that you don't get the second stepped up in basis on the assets in the B trust. And for some of my clients, that's $100,000 to $400,000 savings by getting rid of the B trust. One of the things that I encourage you, I have been trying to find something, create something that gives an outline to what we've been covering today. And in the last year plus, I have created a step-by-step guideline. We have a video that goes along with this, and I'm selling it for $200 per manual, but I really do believe that that is an investment in saving money, because the clients' children that have shown up that have had this and they've read it, it speeds up the process when the time comes, because now they already understand the basics, versus having Holly or I or another attorney sit down and say, okay, now what's going to happen is we're going to have to send off the notice, what Holly went through today. So I really encourage you to at least consider getting this for you or your family. Yes?
Is that information contained in this document?
No. This is the trust. This one says, to my trustee. And it literally is like a checklist. You need to do this, you need to do this, you need to do this. And we have about 4 or 5 different approaches to it. For example, if you're the surviving spouse and one spouse passes away, we have a checklist. If you're a single person and you pass away, we have a checklist. So we have different checklists. We have checklists for incapacity planning, etc. If for those of you that may not have a trust, that I look around and I really do believe that anybody that owns a piece of real estate should have a trust, period. It's that simple. Because your estate will end up going through probate if you don't have a trust. Now, are there people that don't own real estate that I advise having a trust? And my personal opinion is anybody that has minor children, you need to have some estate plan. Because Shannon, who's my office manager, her little girl has been running around here and so forth. But her and her husband, if they were both to be killed in a car accident, the person who would decide who would raise their daughter is the judge in the Orange County Superior Court. On top of it, the law says that a minor cannot receive an inheritance. So the money that I paid for my daughter braces, my daughter went to Taiwan to teach English. My daughter went to Australia she went to school in Australia when she was in high school. The things that I provided for my daughter is not available because the money's blocked and controlled by the judge. But you know when the child receives the entire inheritance? On their 18th birthday. How many of you would want to turn over $1 million to an 18-year-old? I didn't see any hands going up. And so one of the things, even if you don't have a large estate, and I know $1 million, if you don't have a large estate, $1 million, but most people, if you have minor children, you definitely, in my opinion, want to have an estate plan of some sort. Okay? And before we get to the questions, Bill, would you do me a favor? Would you ask them to bring in Tegan and we're going to have our raffle. While we're doing that, what I'm going to ask you to do is inside of your packet is there should be in here a pink, kind of a purple colored sheet, and it's a report card. Perfect. Here is Tegan. She's going to be the one that draws the winning ticket. And make sure that you draw my ticket, okay? All right. You want to read that to them? Okay. Yep, I'll help you read it. How's that? Okay, ready? The last four numbers.
1, 2, 3, 4.
Okay, if you have 1, 2, 3, 4, that's not it. But if you have 8842, there you go. Congratulations. Where is the basket? Might as well bring it in. It looks... And so, thank you, Tegan. You can go now, okay? You're stealing the show. One of the things that I would, and let me just introduce Shannon. If you turn around and look back, well, Holly you've met, but this is the basket that you just won. It's the young lady in the orange jacket. And so, but before we finish up, I wanted just to introduce, I think Gilbert may have left for the day. Has he left? The gentleman who was greeting you at the door is Gilbert. He's worked with me for about 5 years. You've gotten phone calls from Gilbert from my office that put a face to it, just to share something about Gilbert. He was a Vietnam vet, had got Purple Hearts, multiple ones, and he actually re-enlisted because he flew with LBJ in the Marine Corps 1. And so he has been a war hero. Not only did he get Purple Hearts, but he has a lot of other medals that go along for being beyond the Call of Duty type thing. And then Amanda has been, how long have you worked here, Amanda? 4.5. 4.5. And I was going to say 2 weeks, but Amanda is the person, like if you're called to schedule an appointment, Amanda is going to be the one that you're going to be talking to. And she has a legal background, but she also is the person that's on the phone. And then Shannon has been my right-hand person for over 10 years. And she is the brains of the operation that makes this whole thing work. There's Gilbert. Hi, Gilbert. We were just talking about you, and I was saying good things. So I thank you. And but one of the other little things, just to wrap up before we open up to questions, is that if you don't have a trust, or if you have some work that needs to be done to update your estate plan, when you walk out of here, we will give you 2 Jim Roberts dollars, and that's me on that dollar bill. And if you choose to come in and get work done before the end of the year, if you need a trust or whatever, you can apply the $200 towards whatever the price would be, and it'll save you the $200 on our price list. And so that's our little gift for giving up a Saturday to come here. But I don't think it's giving up. It really, one of the things I'm encouraging you to do is spend time talking. And I would just also share with you, spend time talking about advanced medical directive, what you want, type of a thing, because if you've been listed as the health agent, yes, it meets the legal requirements saying you don't want unnecessary life support, but different people have different plans as to what they want. I would spend a couple of minutes, please fill this out. A concern that we have when we're getting ready to do this is that we want to make sure that it's informative enough that you're getting something useful out of it, not so informative that you're just overwhelmed, and that it has to be enough new things when the laws change, etc. There hasn't been a ton of new law changes. Obviously, that Medi-Cal law change, potentially the next year with the Donald Trump tax bills, that would be a change. But please fill out this down here, list any ideas for next year if you have any suggestions or comments. The other thing I'm going to point out to you, and I'll finish this up real quick. Coming back to the first slide, it said something to the effect of harmony is the new normal, and then I crossed off is and said should be. I have spent about a year, a little bit over a year, working on relationships, finding out ways of getting people to get along better. And I would share with you that if you have some disharmony in your family, on your purple sheet, write down, disharmony, please call, whatever. And I will personally call in the next couple of weeks. I'm going to be leaving on the 25th of October to fly to Venice to catch a cruise ship. So somebody's got to keep the cruise ships in business. But between now and then I will reach out, because I truly do believe that if we're going to get along as a country, if we're going to get along with each other, it really starts in the family. And if the families can't get along, how can we expect the nation to get along? And so that's kind of been my situation. And I wish I could tell you everybody in my family gets along great. But I will share with you, I have a son that has some very serious health issues, not per se physical, but very serious health issues. So you can kind of figure out what that might mean. But even with health issues, there's harmony in my household. And my daughter, in the last year, I've become a ballroom dancer. And my daughter and I took up ballroom dancing together. And so I'm bragging when I share this, but I entered into my first dance contest in July. And I entered into 2 categories called beginners and novices. I didn't win either one of those. I actually won Best Overall Male Dancer in the entire contest. So it's a passion, but it is and so I bring that up because there really is harmony even when there's issues, because my son's been diagnosed with a condition, bipolar, and tough. But he's doing well. But he just got out of jail for 5 months that he was in there because he needed to be there to get healthy. And he's doing a lot better. And so we're optimistic. And but again, even with tragedies, you can still get along with each other. And that's what I believe. If you have You want to find out, I'd love to talk with you. That being said, go ahead. Yes.
What takes precedence, the successor trustee or the executor of the will, and how's the difference?
Okay, excellent question, because we have to open it up to questions. If it is an asset that reads James F. Roberts, Gail R. Roberts, trustees of the Roberts Family Trust, so it reads the Roberts Family Trust, then the trustee controls. If it was an account that just reads in Jim Roberts' name, that's outside of my trust, then the executor controls. But 99.999% of the time, the executor and the trustees are one and the same. So the executor controls under the will, the trustee controls under the trust. In our office, they're always the same, and so they really are one and the same. Okay?
If they're two different people, then
Right. You have a specific situation, you might want to come in and just talk about it because there's probably a family issue going on there, and little differences could make a huge difference. But generally, things that are in a trust is controlled by the trustee. Things that are out of the trust are controlled by the executor. If you have, for example, a beneficiary, let's say that there is an account that reads James Roberts, beneficiary Dustin Roberts. That isn't controlled by the trust. That's not controlled by my will. That's controlled because I have a beneficiary listed on my account. And that would control. But come on in, we'll talk about it. Yes?
If the beneficiaries and the trustees are one and the same,
Mm-hmm.
do you have to go through all of those notification things and 120? So you have to send a notification to
Okay.
yourself?
Do you just have, is it just one daughter?
No,
Yeah.
2 dollars.
And are they both co-trustees?
Yes.
Excellent question. His question is, remember we talked about the 16061 notice. I don't know if Holly used that number or whatever, but that's the notice. And what happens is that your 2 daughters would prepare the notice, because it is a requirement, but then they sign saying, I'm not going to contest, and now we're done. We don't have to wait the 120 days. The fastest I've ever had a trust completed, I had a trust one time where a gentleman passed away on a Wednesday. By the following Thursday, the successor trustee had taken a certified copy of his stepdad's death certificate, went to the various financial institutions, collected $160,000, distributed $40,000 to his 3 siblings, $40,000 to himself, listed his stepdad's home with a broker, found a buyer, and was opening up to escrow in 8 days. So it can be done, but I also was involved in a probate that took 13 years. Yes? Yep. Today, I'm leaving it for them. And the idea is that if I leave it to my son or to my daughter, let's use my daughter. If I'm leaving it to my daughter, if she's married, her husband has a presumption that it's community property, and if she's being sued, her creditors take it. If I leave it for her, she has all the rights as if she was the owner, but technically she's not the owner, and therefore her spouse doesn't have a claim to it, and therefore also her creditors can't take it. Okay? Excellent. Anybody else have a question? I wish I could share the last bit of wisdom, but the last piece that I would just share with you is I mentioned to you when your parents take you out to dinner. You notice how I said the parents taking out, because that's what happens in my household. Really, think about it. Your parents came in and spent time that they could have been doing something else. They spent money that they didn't go on a cruise with. And they did it because they really cared about you guys. And they love you guys. And that's really what this is about. And it is a situation that it's not easy. I'm not going to say that going through trust, everybody just holds hands and sing Kumbaya together. But I am going to tell you that my observations have been, I have done a lot of probates. I think I shared, I averaged $6,000 an hour handling a probate. I have spent my career avoiding probate because I know what happens when you go through probate, and I can see what happens when families come together and work together. And that's really what I hope today has been about, is helping build that bridge, providing there. And that's, if you got something useful, thank you. If you didn't get something useful, I still want to thank you, because it wasn't because I didn't try to give you something of usefulness. And but we're here to, and let me share the last piece. I know I figured out something of wisdom. My best advice, if you become the successor trustee, my best advice is 714-282-7488. Call us. We're here to help you. So thank you so much. And I'm not going to stick around too long because I'm supposed to be up in LA. They don't let me rest.